Good afternoon, and welcome to the American Constitution Society's annual Supreme Court Review. I'm LaShawn Warren, Director of Programs at ACS, and I must say I'm delighted that you could join us for this event. So for those of you who are not familiar with ACS, we are a national network of lawyers, academics, policymakers, and law students that promote the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. As many of you may know, the Supreme Court has granted cert in 39 cases thus far for the 2010-2011 term. These cases raise important questions about preemption, consumer rights, free speech, immigration, employment, and criminal law. Our panelists have graciously agreed to highlight cases and trends that merit particular attention. I don't want to take too much time away from the panel, so let me just say that we are very pleased to bring you today's moderator, Professor Rebecca Brown, and 7 panelists, all of whom will bring unique insight and expertise to this discussion. I think you are all in for a real treat. You have the full biographies of all of today's speakers in the handouts that you received at the registration table. So let me just take a moment to briefly introduce Professor Brown, our moderator. She is the Newton Professor of Constitutional Law at the University of Southern California. She served as a law clerk for Supreme Court Justice Thurgood Marshall and for U.S. Court of Appeals Judge Spotwood Robinson. Her scholarship has focused primarily on developing an understanding of the Constitution premised on a relationship between equality and individual liberty. In other words, she is the perfect person to guide today's discussion. So without further delay, please join me in welcoming Professor Brown.
Thank you so much, LaShawn, and thank you to all of you for being here as we embark on what has really become, I think, a fall tradition now with ACS, taking a look at the term to come in the Supreme Court, which will be starting in just a couple of weeks. We're lucky enough to have an unbelievably talented and experienced panel of experts covering a variety of topics, and we're going to try to touch on a whole lot of different things, albeit briefly, and then have a bit of discussion at the end and save some time for questions, and hoping to get some insights about overall our overarching themes from them, as well as just discussing particular cases. As a Californian, I can't help but start by saying I noticed when I looked at the 39 cases in this docket that 40% of them are from the Ninth Circuit. So, seeing as how we don't have a single justice who hails from west of the Mississippi, it seems to me there may be some representation reinforcement needed on the Supreme Court, and maybe some of our panelists, I don't know if they will have an occasion or want to comment on why the Ninth Circuit is being picked on that way, or whether it means anything interesting about the term to come. We'll see. But let me get to our panelists. They're eager to start, and I'm going to give just a very brief introduction of each of them, and I hope that you will look at the fuller biographies in order to get a sense of how impressive and outstanding their credentials to be here really are. But let me just quickly introduce first David Frederick, a partner at Kellogg, Huber and Hansen firm here in D.C. He has argued 21 cases in the Supreme Court, including one that's on the docket for this term, so we hope to hear at least one. We hope to hear from him about that. Next, we have Michael Carvin, who's a partner at Jones Day, has argued numerous cases in both the Supreme Court and all the federal courts of appeals. And next to him, we have Cyrus Mehri, a founding partner of Mehri and Scallett, a firm specializing in cases involving discrimination, civil rights, consumer protection, class actions. Next to him, we have Jennifer Chang Newell, who is an attorney for the ACLU Immigrants' Rights Project. She has devoted a great deal of her career so far to being active in and writing about immigrants' rights, and we will hear her talk about that issue. Next to her is Cynthia Jones. She's an associate professor of law at the Washington College of Law here at American University. And she has devoted much of her time to service in the interest of criminal justice, including serving as executive director of the public defender for DC and currently as chair of the board. Next to her is Cliff Sloan, a partner at Skadden Arps, Slate, Meagher, and Flom, that specializes in First Amendment and media and cyber law. And finally, at the far end, we have Paul Wolfson, who's a partner at WilmerHale with a Supreme Court and appellate litigation practice, and he has argued 19 cases in the Supreme Court so far. So you can see we have an extremely qualified bench of our own to sit and talk about what's going to go on before the court. And with that, I would like to turn it over to David to tell us something about some of the business cases, which are touted to be a very important part of the court's docket this term. What do you think?
Thank you very much. It's a pleasure to be here. I appreciate the invitation and the opportunity to talk with friends and colleagues here about the Supreme Court's upcoming term. I was asked to talk about 3 cases that concern various aspects of consumer interests. The cases are Chase Bank versus McCoy, Cigna Corp versus Amara, and Matrix versus Siracusano. And as I was asked to look at these, I was kind of thinking, what is the common element that I can draw out thematically as to why I was asked to talk about these cases? And one of them might have been that the court granted cert even though the Solicitor General, whose invitation was sought in 2 of the cases, said you don't need to grant cert. But I don't think that's the reason, because Matrix was not a case where the court invited the views of the Solicitor General. So another animating theme of them is that they were unusual cert grants in that all 3 involve very significant changed circumstances, and one could argue that they are not cases that have continuing significance from the basic facts that were presented. In the Chase Bank case, the Federal Reserve Board, whose regulations are at issue, has changed those regulations. In the Cigna Corp case, there has been a change to ERISA practices that are at issue from changes to an ERISA plan back in the late 90s. And in the Matrix case, there's been a change to FDA rules that govern adverse event reporting for over-the-counter drugs. So there's kind of a question here, why did the court want to take these cases when it's not clear that they will have continuing guidance for the future? They all concern questions of notice to consumers. In the McCoy case, the question is what notice needs to be given to credit card holders when the credit card company increases the rate that they pay for fees after they've gone into default. And in Cigna Corp, the question is what notice needs to be given to an ERISA plan holder for a retirement plan when there's a change from a defined benefit plan to a cash plan. And in Matrix, the question is what kind of notice does a company need to give to its investors when it has received information that the product that it's selling may be dangerous. It's interesting that although notice is the one theme that does seem to be running through each of these cases, I don't really expect the cases to turn on that question of what level of notice needs to be given to consumers. I think each of them presents very distinct questions. In Chase Bank, the question I think is going to come down to what level of deference does the Federal Reserve Board get to its regulations concerning information that needs to be given to consumers about credit card charges. In Cigna Corp, the question is a very technical issue about reliance interest that plan participants need to demonstrate in order to show that a change in a plan was flawed. And in Matrix, the question as it has coming to the Supreme Court is a very interesting question involving what may well be a new interplay between social science and law. The question as it is being presented is whether or not event reports that show harm of a product have to be statistically significant in order for there to be materiality under the securities law for the company to omit a disclosure about those reports. So in each of these different areas, notice becomes the overriding theme that I think submerges a very interesting underlying legal issue, and there are very interesting interchanges between administrative law deference to be given to the appropriate agency as well as what information will underlie the basic pleading standards for an ERISA claim or a securities claim.
Great.
And we were all admonished to stay under 5 minutes so that you could hear as much as possible, and I was able to do that. Thank you.
Great job. But please save your questions, and say if you have questions about things he said, save them, and we'll have a chance to let you ask them at the end.
Can I get David's extra 30 seconds?
There's always one in every crowd.
Exactly.
But we're going to turn to Mike, who's going to talk about preemption.
Yeah, and I'm going to talk fairly fast about it because it's a complicated issue, and I've got to get through 3 cases. I think preemption is interesting to Supreme Court observers, mainly because I think the outcomes of the case are difficult to predict because the justices' votes don't fall along the traditional ideological lines that you see in other areas, the 5-4, the 4-1-4 type of stuff. And there's a lot of reasons for that, but in broad strokes, I think it's because, at least from a conservative perspective like mine, there's some competing values. On the one hand, you're very much in favor of federalism and states' rights and allowing states to preserve the health and safety of their citizens. On the other hand, certainly the business community and many other people would argue that if a federal agency has given you certain guidelines and you've complied with them, it's unfair, unpredictable, costly, and counterproductive to have 50 different states, juries within 50 different states, nonetheless imposing liability on you for that, and it creates a disruption, particularly for products that are marketed necessarily on a national basis, and as a consequence, you get some different results, and you get some very strange bedfellows in terms of which justices vote on which side of the issue. I think that unpredictability may be enhanced, actually, now that Justice Stevens has left. The conventional wisdom is that Justice Kagan replacing Justice Stevens may not make much difference, and I think that's probably true in a lot of instances. But I think it's fair to say that Justice Stevens has been one of the most reliable anti-preemption, meaning he won't find preemption pretty consistently, whereas with Justice Kagan, it's certainly an open question. I don't know if she's ever dealt with it in any real way. We may not get the answer to that this term because 2 of the big preemption cases I'm discussing, she will be recused in because of her involvement in the cases or the Solicitor General's office's involvement in the cases. So I think one case in particular illustrates what I would view as the real unsettled area of the law in the preemption area, which is Congress, it's sort of an implied preemption idea. Congress has taken over regulation of a certain area, established agencies, and told companies, businesses, whoever's being regulated, you can do X or you may not do X, but then can the states add on to that regulation? In other words, it's called obstacle or conflict preemption. If Congress says march north and the states say march south, obviously the state law is preempted because there's an inherent conflict. But the tricky area of the law is Congress says march north to Vermont, and then states or state juries in tort cases say, no, you have to go to Canada. So the question is whether the federal government regulation is simply a floor or is it a de facto ceiling that states can't go beyond. Those who would argue it's a ceiling would say, look, it's a cost-benefit analysis. Congress has said Vermont is good, going beyond Vermont is bad, and the states will disrupt this national scheme and create disuniformity and all kinds of confusion. And there's a case called Williamson versus Mazda that I think starkly presents it. And to understand the significance of this case, I'm going to tell you about 2 relatively recent predecessor cases which have confronted sort of the same issue. In 2000, I think, there was a case called Geyer, which is a pretty important case. There, the Department of Transportation said, you must have in your cars airbags or other passive restraints. Somebody brings a tort suit, common law suit, saying this car was unsafe because it didn't have an airbag. The court, in a divided decision, written, I think, by Justice Breyer, said, if you allow this suit to go forward, it will disrupt the entire scheme, and we can't allow that. We have a case now, 2 years ago, that I think David argued, called Wyeth, which had a fairly similar thing. The FDA said a particular warning was safe. a jury came back and said, no, it's unsafe. So again, you had this idea, is the federal government the floor or the ceiling? And in that case, they said, no, it's just the floor. The states can supplement the regulatory regime. So you have this conflict there. And one of the most important points of that was Justice Thomas not only voted that it was not preemptive, he wrote a strong concurrence saying, I don't really buy this whole implied preemption thing, this whole notion that the states can't supplement it. So now you have a strong conservative justice who is actually pretty adamant about not implying this preemption. Turn to Williamson, this case's term, and what you've got is, I would think, a case that's largely indistinguishable from Geyer, where very complicated facts, but basically in rear seats of cars, transportation again said you could use type 1 seat belts, which is the old-fashioned, across the waist, or type 2 seat belts, which is the shoulder strap kind of seat belts that you see in the front seat. And now there's again a case claiming that they should have had the type 2 seat belts. So it looks very much like Geyer. And the interesting question is whether or not they'll follow it. The Obama administration has come in on the other side of this, and it'll be interesting to see which way this goes if they cut back dramatically on Geyer. I've basically used up all of my time on this first question, so I will basically say there's an interesting case that David is also arguing in the drug area called Brusewitz versus Wyeth, which is a question involving whether or not this special vaccine compensation scheme that the federal government has devised basically rules out certain kinds of state law tort claims. It turns on a very specific question of statutory language, which I don't have time to go into. But I will say that in broad strokes, it looks like a case where you would typically find preemption. Vaccines are things that, and I'm doing this all because if he does win this case, then everyone will say, I'll tell you what a terrific advocate he was. So I will, I'll tell you the headwinds facing David as he goes into this case, which is, we are talking about vaccines. We're not talking about cigarettes or bad stuff. We're talking about stuff that we want to encourage people to do. Congress has set up a special scheme to provide compensation for people injured by vaccines, so it's not a stark choice between no remedy or, which it is sometimes in the preemption case, there will be that. The FDA does heavily regulate vaccines, and finally, the Obama administration, in contrast to example for the Williamson case, has come in and said that it's preempted. So only the most skilled advocate could overcome that kind of array of things, and I'm sure David will prevail quite easily.
It sounds like an invitation to say something if I ever heard one. Would you like to respond or say anything about your case?
Gosh, I've got it tough here when Mike makes the argument, and I've run out of time.
So the final case is actually not really a preemption case, and I suspect other folks are going to talk about it. It's this Federal Arbitration Act case called AT&T Mobility versus Concepcion that raises some very interesting questions about whether or not you can exclude class-based arbitration, and I'll leave it at that.
Okay, so you really don't want to, okay, maybe that's after.
Yeah, if there's time later.
All right.
Sure.
So we're going to move on to Cyrus, who's going to talk about some of the particular instantiations of employment law, particularly retaliation claims.
Yes, sure.
Why are they so important? Why does the court like those so much?
Well, that's an interesting question. I think one of the great paradoxes of the Roberts Court is as they're kind of a wrecking crew dismantling the employee's substantive rights, cases like Ledbetter that are so famous, or the Gross case recently. At the same time, they have a very robust view of employee rights when it comes to retaliation, and they have taken in cases in almost every term the last few years. They found that there's anti-retaliation rights under Section 1981, which is a race discrimination statute. They've, in the Crawford case in 2008, 9-0, saying that witnesses in an investigation are protected from the anti-retaliation statutes. In Burlington Northern in 2006, again, 9-0, they kind of defined what's an adverse action against an employee in a kind of an employee-friendly way, which is, would they, as a reasonable employee, view the action against them as retaliation? And another way of looking at it was the action against the employee, would that have a deterrent effect on others speaking up and advancing their civil rights? So at the same time, they have this very robust view of retaliation, and the statutes are weakening on a substantive view. I wonder if down the road we'll have jurisprudence where you have this great right for anti-retaliation for substantive rights that you can't really effectively prosecute. So that's where they came to be, where the crossroads seem to be going. But the two cases that are up right now, one is from the Seventh Circuit called Caston versus St. Gobain Performance Plastic Corporation, and the other one is Thompson versus North American Stainless. The interesting thing about Thompson is the plaintiff is a fellow named Eric Thompson. He did not bring any EEOC charges or advance any rights of himself, but his fiancee did. And she brought an EEOC charge, and their wedding present was a terminated Eric, arguably for his future wife's advancing her EEOC charge. And so the question there is is going to be whether or not that kind of by association there's the retaliation claim there. And I think one of the interesting things is that in the substantive area of Title VII, there is protection for by association. At least a lot of courts have found that. So, for example, in an interracial couple, if one person gets discriminated against based on race, even though they're not in the protected group, that they could maybe advance a claim. So one of the interesting things for me is going to be to see whether they will look at the substantive area when they look at the retaliation area. The other case is an FLSA case, and what happened there is the person who has the retaliation claim made a complaint, but they didn't do it in writing. And the question is whether that's sufficient enough. The lower court, the district court, said no, it had to be in writing, and they had an interpretation of the word, it must be filed, to mean it must be in writing. And then the Court of Appeals, the Seventh Circuit, agreed with the district court. So the question now is the Supreme Court going to have a robust enough view of retaliation that they're going to look at that and say, well, look, it doesn't matter if it's in writing or oral. The key is that they expressed their complaint. My hope on that case is whatever the outcome is, they come up with a common sense look at this, like really look at what happens in a workplace. Because, for example, you could have someone talks about it verbally, but then it gets memorialized in writing. Is that sufficient? Or you could look at it from an employer point of view and say, well, unless it's something official, there's no way to really document it if it's only in writing. Or it's a declaration or affidavit enough. So however they resolve that case, I think it would be good for both the employer side and the employee side to take a real common sense approach to that. But I do want to mention the AT&T case, which is about class action bans. That, to me, is probably the most serious case, threatening the rights of employees. And I felt last term the progressive community missed the importance of the Stolt-Nielsen case, which had a silent arbitration clause. And I think this case that the prior speakers only briefly got a chance to talk about, it has some potentially very serious ramifications. That's it.
Okay, well, immigration and treatment of immigrants is in the news all the time, and we see the court is starting to weigh in. I wonder if you could talk about things in the pipeline as well as cases on the docket. Jennifer.
Sure. So I think the main case that I was asked to talk about is the Chamber of Commerce versus Whiting case. And the case concerns the power of states and localities to regulate immigration. It's a challenge to an Arizona state law which sanctions employers for employing undocumented workers and which requires that employers participate in a voluntary federal electronic verification program called E-Verify. And the ACLU's argument is essentially that there's already federal immigration laws covering these areas, and that the Arizona law is both expressly and impliedly preempted by those federal immigration laws. I think it's important to step back a little bit and talk about the backdrop. So this Arizona law, as everyone knows, isn't the only Arizona law, and it's not the only, Arizona is not the only state trying to regulate in this fashion. Starting about 5 years ago in 2005, states and localities started proposing all sorts of kinds of immigration-related laws. In the past 5 years, the state legislatures have proposed thousands of them, and they've enacted hundreds of them. One of the very first laws was a law in Hazleton, Pennsylvania that has been in the news recently. We've been litigating that challenge for 4 years, and that law involves a law that prohibits undocumented immigrants from renting in the city of Hazleton, Pennsylvania, and which also restricts employment of certain immigrants. And as many of you know, just the other day, the Third Circuit issued a 188-page decision holding that that law was preempted. And that issue is half of the case. The employment side of that case is essentially the same or very similar issue as what's in front of the Supreme Court in the Chamber of Commerce versus Whiting case. There's been other laws as well, the Arizona SB 1070 law, which is one that doesn't involve housing or employment, but it involves immigration enforcement by local police and county sheriffs. That law, just very briefly, authorizes, for example, warrantless arrests of immigrants for being removable, which is not actually a federal crime. That's a civil immigration offense. As you know, recently, I think at the very end of July, a district court judge in Arizona held many key provisions of SB 1070 preempted. So the issues in the Chamber of Commerce case in the Supreme Court are closely related to these issues that are coming up because all these states and cities are really active in this area and are passing a lot of these laws. They're all part of the same trend. I think the general perception is that the federal government's not doing enough on immigration, and so if the federal government's not going to do it, then we better do it ourselves. And it seems to reflect a hope that if states and cities can make life very difficult for immigrants, whether it's housing or employment or policing, that they'll just leave. And these laws also, in our view, they cause discrimination against immigrants. If you have a law that says you can't, you're going to suffer severe penalties as a landlord if you rent to someone who turns out to be undocumented, people are going to start essentially racially profiling applicants for housing. And we've seen that. And so as a result, the ACLU has been litigating these cases since about 2006. And this Chamber of Commerce versus Whiting case is the one that sort of bubbled up and got to the Supreme Court. And as Mike mentioned, preemption can kind of involve strange bedfellows. This is an example of that. As you know, the case is called Chamber of Commerce, but it's also an ACLU case. Some people might say that it is an immigrants' rights case that's dressed up in business clothing, or vice versa. The Solicitor General has also weighed in on this case, both at the cert stage and in the merits stage. In terms of the potential impact of this case, I think states and cities and immigrants' rights advocates are all watching to see if the Supreme Court is going to send a signal as to whether states should be in the business of regulating immigration. And I see that I'm out of time, so the last thing I'll say really quickly is there's another really interesting case, immigration case in front of the court this term called Flores VR, and it concerns an issue of citizenship at birth and whether so certain individuals who are born to U.S. citizen parents are considered citizens at birth, even if they're not born in the United States. However, there's pretty significant differentials as to who can become a citizen at birth, depending on whether the U.S. citizen parent is a mother or a father. And in this case, this individual's father was the U.S. citizen, and as a result, because of the residency requirement, the government argues that he is not a U.S. citizen at birth. And the reason why the case is constitutionally significant is because the question in the case is the question of the level of scrutiny that should be applied to a gender classification in the context of this citizenship statute. And the government argues that because this involves immigration and naturalization, that a very deferential standard of review should be applied. And that's called the plenary power doctrine. And for decades, there's been this outdated concept that immigration is an exception to constitutional protections, and that when the federal government's acting in that area, a more deferential standard of review should apply. And obviously, people who are familiar with gender discrimination doctrine know that ordinarily it's a heightened scrutiny should apply.
Very interesting. Cynthia, you're going to get us into the thicket of criminal justice cases this term.
So far, no one has died in any of these cases. That's about to change. The two cases I'm going to talk about, Skinner versus Switzer and Connick versus Thompson, both signal what has been happening in the last few years, and that is the Supreme Court is struggling to figure out what to do about people who have been convicted, but they are actually innocent. They have, since 1989, we've allowed DNA evidence to be used, and it's now been used to exonerate over 250 people, yet there are problems along the way, either when someone tries to gain access to DNA evidence or someone tries to introduce it at various stages in the proceeding. And the Supreme Court has struggled with this notion of what are we supposed to do if at some point after you've been convicted, you come forward with evidence that you are actually innocent. Is that a constitutional violation? And in a case called Herrera, the Supreme Court said about a decade ago, well, if you have a truly persuasive showing of actual innocence, that could, standing alone, be a constitutional violation. And I thought, well, thank you. It would be, it seems intuitive, but they had to think about that. In Skinner, a defendant has been convicted and was sentenced to death and was hours from execution when the execution was stayed because he said there is definitive, dispositive DNA evidence in existence that the government has that they won't let me test. And the government says, we don't have to let you test it. Most jurisdictions around the country now have innocence protection statutes, these post-conviction DNA statutes that give you right to test. Under the Texas statute, this individual did not have the right. Now, in a case decided last year in Osborne, the Supreme Court said it's not a denial of due process if in the absence of such a statute, the state simply says, we won't let you test the DNA. Even if you're on death row, even if it would be dispositive, that's not a due process violation. And Alito says, well, that would cause defendants to sort of try to play games in the system and say, I'm not going to assert or request DNA testing in advance. I'll wait, and if I get convicted, then I'll seek DNA testing. The reverse actually ends up being true. The government doesn't have to use DNA evidence to convict. They can rely on their witnesses. Even if there's DNA there that would definitively and dispositively tell us exactly who did it, they can not test it, rely on their witnesses to meet their burden of proof, and then when the defendant later says, I want the DNA tested, they could say, no, we don't have to let you. So in Skinner, he tried to get around the Osborne problem and not assert a due process violation. He's asserting that this is a violation of his civil rights. He filed the Section 1983 action. The case actually turns on a very technical point as to whether he should have filed a habeas action or whether he can bring this 1983 claim. In essence, the court is going to have to deal with, either in this case or another case, what should we do when there is evidence that could exonerate someone that's out there and the state won't give them access to it? Or how do we acknowledge in our criminal justice system that there are correctable flaws outside of the normal process? So that's the issue in Skinner. In Connick versus Thompson, slightly different. One of the other major causes of wrongful convictions beyond eyewitness mis-ID and coerced confessions is Brady violations. Under Brady versus Maryland, if the government is in possession of evidence that is exculpatory, they have a constitutional duty to turn it over. It's an obligation that has existed since the 60s, and I would submit has been violated since the 60s on a regular basis. There's not much dispute about that. And so Mr. Thompson is convicted, and he's sentenced to death, and it is discovered that the government has intentionally suppressed exculpatory evidence. In a very dramatic fashion, one of the trial prosecutors finds out that he's terminally ill and dying of cancer, has months to live, and says to a fellow prosecutor, I intentionally suppressed the evidence that would have exonerated him. He then dies. The prosecutor, he told, remains silent about it until the defense independently discovers it later, years later, as a matter of fact. The defendant is eventually exonerated of the offense for which they withheld the evidence and acquitted of the other offense for which he was on death row. And he sued under Section 1983. And there's a case, Vandekamp, last term, where the court says prosecutors have absolute immunity for performing a prosecutorial function. Disclosing evidence is a prosecutorial function. Making a decision not to disclose evidence is a prosecutorial function. But in a series of cases, to get around the absolute immunity, courts have said, however, destroying evidence is not a function of your job. And so that ends up being a problem. But he didn't destroy it. He just suppressed it. He just withheld it. And so to get around the immunity problem, Mr. Thompson said, I am suing you under Section 1983. I'm suing the office for failure to train the line prosecutors on their disclosure duties. You were recklessly disregarding the fact that they didn't know what to do and they didn't do it. And the government said, you can't sue us based upon that. You only have one Brady violation. You don't have a pattern. The lower court and the Fifth Circuit out of Louisiana said, you don't need a pattern. One Brady violation alone is enough. It's actionable. And so the issue before the court is, how strong is this prosecutorial immunity is it going to be, or will you recognize the fact that one Brady violation, which in this case was outcome determinative and put him in on death row, is sufficient? This was a $14 million verdict in favor of him against the prosecutor. So those are the two cases that are before the court on those two areas.
Thank you. Cliff is going to talk to us about two very interesting, I guess, First Amendment cases. The court has shown a great interest in the First Amendment, as we all know, Citizens United being one example last term, a strong interest in absolute protection of speech, and hoping Cliff will enlighten us on why they might have granted the two cases that he's going to talk about.
Okay, great question. And before I get to it, I just want to mention that this is the first Supreme Court panel I've been on where there are just about as many panelists as justices. And I think actually what we should have done is each of us should have been a justice for the panel. So we should try that. But the two cases that I'm going to talk about are Snyder versus Phelps and Schwarzenegger versus Entertainment Merchants Association. As Rebecca mentioned, they're both very interesting, potentially important First Amendment cases. The Snyder versus Phelps case, which has gotten a lot of attention, has to do with a protest at a military funeral, a protest that most people would find very offensive. I'll get into that, and the slain soldier's father sued the pastor of the church and the church that had organized this protest, which had about 7 people, the pastor and 6 members of his family, and he recovered $5 million in a jury verdict based on state torts of intentional infliction of emotional distress and invasion of privacy and conspiracy. The Fourth Circuit set it aside on First Amendment grounds, said it was protected speech. And in the Schwarzenegger case, California passed a law that prohibited the sale or rental of violent video games to minors under 18. The Ninth Circuit, like other courts, struck it down as unconstitutional, and the Supreme Court will be considering the constitutionality of it. Now, the question that Rebecca mentioned about why did the Supreme Court take these cases is something that a number of people have raised. With the Schwarzenegger case in particular, they say, look, there have been several courts of appeals decisions on these violent video games, all striking them down as First Amendment. No split in the circuits. Why did the court take it? People say in the Snyder versus Phelps, here was the Fourth Circuit, in its view, applying settled principles. Why did the court take it? I actually don't think it's that very surprising that the Supreme Court took either case. First of all, with the California case, look, you have a court of appeals striking down a state statute as unconstitutional. Not too long ago, that kind of case was mandatory for the Supreme Court to take. And in doing away with mandatory jurisdiction, there were a lot of assurances that those were exactly the kinds of cases that the Supreme Court, in its discretion, would still take. And as we know, Supreme Court's docket is not exactly overcrowded these days. And so I actually think that, in general, it makes a lot of sense if a federal court is striking down a state statute as unconstitutional for the Supreme Court to consider it. And I think really the same thing applies with the Fourth Circuit's opinion. I mean, here you have a court pulling out its constitutional power, using the First Amendment to set aside a jury verdict based on state torts, saying that the First Amendment commands us to set aside this jury verdict, commands us to limit these state torts in this way. And again, I think that's perfectly appropriate and in many ways to be expected that the Supreme Court would do it. So I don't kind of share the kind of baffled reaction that a lot of people have expressed about why is the Supreme Court taking these cases. But let me just make a few additional comments about each of the cases and some of the issues that they present and some of the things to look out for in them. And again, just in a little more detail on the Snyder versus Phelps case, which is going to be argued the first week of the court's term on October 6th. And Matthew Snyder, who was a Marine corporal, was killed in Iraq. His family was having a funeral for him at their local Catholic church in Maryland. And this guy, Fred Phelps, who's a pastor at the Westboro Baptist Church in Kansas, learned about the funeral. His church consists of about 70 people, about 50 of whom are in his extended family. And they have gotten into the practice of protesting at military funerals. They showed up with signs such as, saying things such as, God hates fags, thank God for dead soldiers, God hates you, you're going to hell, priests rape boys, and all kinds of other signs in that vein. I actually see I'm running very low on time, so I'm going to give a very quick summary of a couple of points that I think are of interest in the case to look out for. One issue that I think is very, very important in the case is this whole question of the intersection between the First Amendment and state torts. And the Fourth Circuit thought it was applying settled principles that beyond the defamation context of New York Times versus Sullivan, where you have these ringing First Amendment principles, in other torts, the Supreme Court has similarly applied First Amendment principles, such as in Falwell versus Hustler, where Jerry Falwell sued Hustler over a parody. It was intentional infliction of emotional distress, and the Supreme Court applied a full, robust First Amendment analysis there. The Fourth Circuit thought it was doing the same thing here. Now, the argument, and it said this was that the statements here were about issues of public concern, however offensive, and they were rhetorical hyperbole, so they were protected by the First Amendment. Snyder argues that because he's a private individual and because this was a private event, there should be a much lower standard. But one thing that I think is very important to watch for in this case is that this whole question of the intersection between the First Amendment and state torts is a potential sleeper. You know, Justice Scalia was quoted not too long ago in a book by Norman Pearlstein as saying that in the appropriate case, he would be willing to reconsider New York Times versus Sullivan itself. And so you have a situation where New York Times versus Sullivan, which was this kind of seminal application of the First Amendment, trimming, cutting, restricting state tort of defamation that impinged on First Amendment values, is kind of in the background here. And it'll be interesting to see how this general issue of the intersection between torts and the First Amendment play out on that. Last point I'll make is that this will be very interesting to see what we learn about Justice Kagan and the First Amendment in these cases. These two are among the half of the cases that she's not recused in, so she may have particular time for them. And we also know that in her, both as a practicing lawyer and as an academic, the First Amendment was a subject of particular interest and concern to her. She wrote articles about it. She had cases about the First Amendment. So it'll be particularly interesting to see what she does.
Thank you. And finally, we're going to wrap up this part of the program with Paul telling us something about the religion cases that have been granted this term.
Great. So I'm just going to talk about one case, but it is really a perennial favorite, or two perennially favorites, actually. It involves government aid to religious schools and taxpayer standing. So for those of you who followed the Supreme Court's religion jurisprudence know that almost all of the cases tend to be deeply ideologically divided, often, usually 5-4, and very often they flip on very, very narrow, what appear to the general public to be very, very narrow differences. So, for example, you can have a nativity scene, but only if it's right next to a menorah of exactly equal size. You can set up the Ten Commandments, but only if it was done basically before 1930. And as for government aid to religious schools, the Supreme Court's jurisprudence in the 1970s had developed to a point where it was considered constitutional for the government to give maps to schools, but unconstitutional for the government to give globes to religious schools. The court's jurisprudence on government aid to religious schools started taking a significantly different turn in the 1990s, and where the court started taking a much more relaxed view, a much more lenient view towards government aid to religious schools, as long as the aid was part of a broad program that was afforded to all schools, public, non-religious private schools, and religious private schools. So the court upheld the Elementary and Secondary Education Act, which provided sort of aid for low and moderate income children, even if they were in religious schools. And in the very important case in 2002 called Zellman versus Simmons-Harris, the court upheld a school voucher program, which was a program under which the government provided vouchers to parents, and the parents could then choose of their own volition whether those vouchers would be used at a private school, and it could be a private sectarian school, it could be at a private non-sectarian school. But the key to the courts upholding the program was that it was not really, or was not viewed as government aid to the school itself. It was viewed as government aid to the parents, and then the parents could decide, of their own volition how the aid would be used. And if that was to a religious school where the tuition assistance was used, well, that decision was attributable to the parents and not to the government. This case, the case I'm going to talk about, Arizona Christian School Tuition Organization, the title gives away a lot, versus Wynn, is a really interesting version of this, although completely unique as far as I'm aware, to Arizona. So Arizona has a very interesting system where organizations can set themselves up as school tuition organizations. And parents can, or not just parents, anybody, can give money, can donate money to a school tuition organization. And then the school tuition organization can use that money to fund scholarships to schools. So the scholarships do not have to be provided on a neutral basis. The tuition organization can use the scholarship just for Christian schools or non-Christian schools or non-religious schools, however they want. There are two sort of key points about it, though, that are really interesting and make the case potentially different from the other ones. One is the money that the parents give to the tuition organization, that is actually a tax. The subsidy is done by a tax credit, not a tax deduction. So it's literally, if your tax bill to the state of Arizona is $1,500, and you want to give $500 to this organization, you basically send $1,000 to the state and $500 to the organization. So it really is like, or the plaintiffs would argue, it really is like the government just giving $500 of the taxpayers' money to the school tuition organization. Then the school tuition organization itself has, does not have to give its money out neutrally. So it can decide we're going to give money. The donations that we get from our contributors will be given to schools that prefer students of a particular religion or what have you. And the vast majority of the money given by these school tuition organizations is to religiously affiliated schools. So, it will be interesting to see if the Supreme Court extends the Zellman principle to this kind of system on the ground that it really is attributable just to the citizens deciding who they want to give their money to, and so it's just like vouchers. Or if they conclude that the sort of these two features that I just mentioned make it different and make it more like the older cases where the court had been much less tolerant of direct state aid to religious schools. The other point I want to make, and I see my time is up, is there is a question about whether the taxpayers of Arizona have standing to challenge this program. This is another area in which the court has been very divided. And just a couple of years ago, there was a case called Hine versus Freedom from Religion Foundation, where the court ruled that the taxpayers did not have standing to challenge a U.S. government program. And there was much debate among the justices about whether to cut back on an older case called Flast, which is the kind of the prominent decision in this area. So that issue is also a significant issue in this case, and I predict it'll be 5-4.
With Justice Kennedy in the majority.
Who knows?
Well, thank you so much. That wraps up our portion of the program where we were going to talk specifically about cases. But before we open it up to questions from the audience, I'd like to ask, it's hard to start this term without at least acknowledging that there's a new justice on the court and one who's no longer there. It's been talked about quite a bit this summer, but does anyone think that there's something to say now about, Mike mentioned that there was an area in his mind that where Justice Kagan might actually make a difference. Does anyone see a potential for changes on the court's jurisprudence in any sense, either based on her own judicial philosophy or perhaps her lack of seniority compared with the high degree of seniority of the person she replaced? Does anyone have a thought about whether it'll make a difference?
Let me just throw out a couple quick thoughts. One thing is that it takes a while for a justice to get in the groove. I mean, Justice William O. Douglas famously said it takes a few years to know your way around the track. And if you look at the commentary on Justice Souter after his first year or two, Justice Blackmun after his first year or two, very different from how they turned out as justices. So who knows? I think the idea that, by early November we're going to kind of know the impact she's having on the court, is unrealistic, or maybe even this term. That's one point. The other point I just want to mention, one thing that has gotten a lot of attention in her nomination was the role that she played as Dean of Harvard Law School in bringing different factions together. And one of the things that she did quite successfully with that was have a lot of free food, donuts and that kind of thing. So, another Harvard Law School professor one time told me that she thought that Dean Kagan's view was that if people are eating, they can't complain. So the question that I wonder is whether in the Supreme Court in the conference room she's going to start bringing lots of boxes of donuts and that kind of thing, but we'll see.
I'd just like to say that we all should honor Justice Stevens' long service to our country, not just as a Supreme Court justice, but as a Seventh Circuit judge in the military and in private life when he engaged in a number of public actions in his private law career. I mean, this was somebody who really dedicated his life to the service of our country in a very profound way. And it's often said that a justice changes or grows or evolves or moves, and you can use different ways of describing that depending on your perspective on whether that's a good thing or a bad thing. But one of the things that I noted about Justice Stevens is that once he thought about a problem and he committed it to writing, he almost never changed. He thought that was correct, and I had a case once where the issue is whether a footnote he wrote in a Seventh Circuit opinion was still the right way to think about the problem, and he was most adamant that he had gotten this right as a Seventh Circuit judge, and the case is obviously in the Supreme Court. But an argument was the consummate questioner. His questions were so politely framed but devastating in their ability to get to the core of the case. And he almost always waited until the end of the argument because he wanted counsel to have an opportunity to have his or her say. But then when he sprung his question, if you weren't prepared and you didn't see where he was going, he could lay the trap with just devastating effectiveness. And I saw several cases where he essentially got counsel to concede away the case by the way he framed his hypothetical questions. And that kind of skill and attention to the detail of the work of the court is something that we should honor and appreciate, because he could have retired a long time ago, and he's basically been working for free, near as I can make out from what he could have drawn from his retirement pay.
I'll just briefly echo. I disagree with Justice Stevens probably 99% of the time, but having said that, I will echo first David's point about an oral argument. And this might be one of the serious changes, because Justice Stevens was from the old school, I think, where he'd let you make your argument, and he was very tactical in how he asked your questions. And the flip side of what David said was, with me, they were tended to be adversarial. So if you knew that and gave him a good answer, he wouldn't get offended or anything. He'd be like good lawyering, kind of clever, and he wouldn't get upset if he was having a dialogue with you, even though you were coming from different perspectives. Justice Kagan obviously has never sat as a judge. She's going to be in a very different position sitting on that side of the bench as opposed to as an advocate. So I think getting her sea legs up front will be, and this is a very hot Supreme Court. I mean, a lot of people talking except for Justice Thomas, to see how she's going to wade her way in there, and is she going to be more strategic, or Justice Breyer sort of just gives you a stream of consciousness. Here's what I'm thinking about, kind of, and which school she'll participate in. So.
Well, I know Cliff has gone on record as calling Justice Stevens the best justice in history. Just out of loyalty, I have to say I don't necessarily agree, but I would certainly, if you wanted to say something in support of that position, it would be interesting to hear.
Sure. As Rebecca mentioned, I wrote something saying that Justice Stevens should be recognized as the greatest justice in Supreme Court history, and I do believe that when you look at the impact that he has had on the law in a wide range of areas, including particularly prominently in enforcing the rule of law in the past several years. And if you compare that to kind of other times in our national history where the court's record on issues because of perceived exigencies and urgency is not a happy record, but in many, many areas, and we could talk about that for a long time. But whether or not you say the greatest, I certainly think he is one of the greatest, and I think that he has, his legacy will endure. But I think that something very important that both of the previous comments emphasized is that he really was a judge's judge, which is how he was described at the time of his nomination to the Supreme Court by Senator Charles Percy of Illinois, who had been his patron. When he was nominated to the Seventh Circuit, Percy said he was a lawyer's lawyer, and when he was nominated to the Supreme Court, Percy said he's now a judge's judge. And he really is the embodiment of, I think, what you want in a judge in terms of, in just exactly what you've heard, this very careful attention to the case, this sense of a fair hearing, and in that sense, I think he will. I think he also really embodies the rule of law. And Mike was nice enough to kind of say, even though he disagrees with him 99% of the time, but one of my favorite stories about Justice Stevens, which I think really illustrates this, is that everybody remembers his passionate dissent in Bush v. Gore, and where he said in his last line that the real loser is the country's faith in an impartial judiciary, or something along those lines. And a former official from the Reagan Justice Department, one of Mike's colleagues, said at the time, that'll never be true as long as Justice Stevens sits on the court. And I think that fact, that whether you agreed with him or disagreed with him, you knew he was acting as a judge's judge, is really a testament to his greatness and to his legacy.
Anybody else want to add anything before we move to questions? Wow. You don't usually get silence from a group of lawyers like this. But I think they are eager to hear what you guys would like them to talk about. I'm going to open it up first to members of the press. If you would, please wait for the microphone and state your name and your affiliation. And try to keep your question brief, because we want to hear from the panelists as much as possible. Yes? She'll bring you the mic.
Mark Gruenberg from Press Associates. We gave short shrift to what sounds like a very important case, which is the AT&T case. Let's go into that in a little more detail, and particularly, I think it was Mr. Mary who mentioned that it could threaten the rights of employees. If you could talk about that, please.
Sure, please.
Sure. It's a case I think threatens the rights of both consumers and employees. That case is the issue, and no, this is your topic, so you should jump in. Is whether or not a ban on class actions is unconscionable, and then part of the question is how much deference should be given to the states, whether it should be looked at state by state or should be kind of a nationwide pronouncement on that issue. The reason why I think there's so much at stake on that is that if the Supreme Court says that it is not unconscionable to ban class actions, what you will find is over a period of time that every consumer contract and every employee will be subject to a mandatory, not only mandatory arbitration, but a class action ban. And that will essentially take statutes like Title VII and civil rights and other statutes and make them, just take out all their enforcement power, because it's really the tool is to bring about systemic change in the workplace is a class action tool. That's how you bring about programmatic relief. That's how you bring about changes in policies and practices that discriminate. So I think you're going to see the access to the courts in the most meaningful cases potentially be wiped out if that case comes out where they seem to be trending based on their prior decisions. I know you'll disagree with some of that, if not all of it. But.
Well, certainly agree on the stakes. I think it's a very important case, and I do agree whichever way the court decides. This is one of the cases out of the Ninth Circuit, so it comes with the presumption of reversibility. And I do think that if you cannot ban class actions, I think whichever way they come out, it'll have a profound effect on future arbitrations. I don't think there's a good statutory argument that this is permissible. There's a Federal Arbitration Act which said to the states, don't harass arbitration agreements. If two parties get together and decide that they would rather have low-cost, effective, quick resolution of their claims, you can't undo that unless you do it on a ground that uniformly applies to all contracts. And the notion that saying we won't allow you to do a class action on top of this arbitration is somehow unconscionable, of course, twists the concept of unconscionability. Unconscionability is whether or not it's fair to you. It doesn't involve whether or not they've allowed you to pursue all procedures. When you agree to arbitration, you've waived jury trials and all the other kinds of protections. So why would the ability to waive a class action be any different? Particularly because in this case, the district court described quite accurately the arbitration agreement issued here as one of the most generous he'd ever seen. It provides $7,500 if the customer prevails, double attorney's fees, and all kinds of things that do make this kind of arbitration very low cost and effective. Even if you get beyond the statutory question, I think there's a real genuine policy issue is whether or not the whole point of arbitration is obviously there's certain things like fights with your wireless carrier that nobody's going to bother to go to court, small claims court, and litigate. So the idea is that if you have an arbitration thing, you will actually resolve these disputes in some way, particularly a fair arbitration agreement like this. Now, even from the consumer's perspective, are they better off with a one-shot, quick arbitration or getting stuck in a class action that's going to last for years and years, where they're dependent on the plaintiff's lawyers to dole out the money? So it's not at all clear to me, even if you look at it strictly from the consumer's perspective, whether or not the class action is preferable to the single, quick arbitration and the relatively cheap arbitration, particularly in light of the fact that the Congress has made it clear in the act that these kinds of policy decisions are not for courts to make, are not for states to make. It is for the parties to make between themselves.
Can I just
Sure.
respond to that? This is where Justice Stevens is really going to be missed because he made it clear in a series of cases that when you go back to the original arbitration statutes that came out of the 30s, that they were parties of equal bargaining power. So you tell me how many people in this room can really negotiate against a big corporation when it comes to getting their wireless service or any other kind of thing, or what employee. Sometimes mandatory arbitration comes in at the applicant stage when someone is applying to a Waffle House, they have to fill out a form in little tiny print where they've given away these rights. I think a really good place to also to look at is the oral argument in the Stolt-Nielsen case, where Justice Ginsburg raised the concern that this was a vanishing right that people have and that could easily be squandered. So I think it's a very serious concern, and I think the imbalance of power really gets underscored in this area.
Can I just jump in and make an historical point, which is that when the Federal Arbitration Act was enacted by Congress in the mid-1920s, the perception at the time was that judges were hostile to arbitration, and the whole point of the FAA was to protect arbitral rights. But that was in an era when the class action mechanism was very rarely used, when the notions of consumer rights were not really the subject of litigation. And we've now come to the point where over the last 20 years, the presumption has almost flipped, and so that instead of having a hostility to arbitration, we now seem to have such a warm embrace of arbitration that these other access to justice type issues in the court system have gone, to the wayside. And the question ultimately is one of congressional intent. I mean, as Mike will acknowledge, in the preemption area, that's the touchstone of every preemption case. And the question here is it time to revisit by Congress how these relations ought to be done? Because you've got this act that has got some fairly vaguely worded provisions, and there's a lot of judicial importation of principle and policy in the wording of the Federal Arbitration Act. And it may well be time for Congress to go back and take another look at, is the act serving the purposes for the kinds of dispute resolution that we have today?
Good. More questions from the press? Yep, are you? Sure.
Hello? Back here? Back here? Back here. Hi, Rebecca. Back here.
Okay.
Hi, it's Ken Joseph with CQ Press. I wanted to ask Cliff and or others what you make of Justice Kagan's views on the First Amendment from what she's written. I had difficulty discerning her orientation, and I wonder if you did a better job than I.
I'm looking forward to seeing what she says in these cases. I think it's correct that in her writings on the First Amendment, it's not as though she has staked out a kind of distinctive, clearly identified position that would give rise to kind of predictors about how she would approach these issues. I think the only thing you can say is that it's a subject of great interest to her. But I would agree. I mean, I think the kind of tenor of your question is that you can't really tell from her writings and kind of exactly where she's coming from on the First Amendment, other than she's very interested in it. And I think that it is true that in the litigation that she did, and in which you can't always tell someone's personal predilections from, but in her writings, she's got a lot. It seems as though she's got some sort of pro-First Amendment inclinations, if you want to put it really simplistically like that. But I do think that that it kind of remains to be seen how she's going to manifest that interest that she's displayed.
We had a question up here, please.
I'm Greg Storr with Bloomberg News. Could somebody speak to the recusals of Justice Kagan and how that might affect the term? And is there a significant prospect that a lot of the cases you've been talking about will wash out as 4-4 decisions? And if there are any particular cases where you think there's a good chance of that happening, could you bring that up, please?
I did mention, I think, the two preemption cases, which, as I say, she is recused in. It might have a very important effect in this Williamson case I was talking about. It'll depend, frankly, on where Breyer and Kennedy vote. It could either be 4-4 or 5-3 either way. Since David's got a stone-cold loser in the other case, it may not matter. No, I won't go back there. That one is a little more difficult to predict, but whether that's going to be a 5-3 kind of case, I really don't know. I was just looking through my list of other cases that we've discussed. One case we haven't discussed, actually, an interesting, this NASA v. Nelson case, which is this constitutional privacy challenge that she is recused in. Flores Villar, which I think we did discuss, she's out of that as well. Chamber of Commerce v. Whiting, the big Arizona immigration case, she's out there. County of Los Angeles v. Humphreys, and some other ones. But I think those are the big, and the Thompson versus North America Stainless, the third-party one. She's also out of that as well. So, yeah, obviously it'll have a fairly, at least a number of those cases we talked about in the traditional world would be 5-4, so they could wind up 4-4, equally divided, no decision, or 5-3 or something like that.
Jennifer, did you want to speak to this?
In the Flores VR case, it's pretty interesting because that issue has come up twice before in the Supreme Court in a case called Miller versus Albright, and then in a case called Wynn versus INS. And in both of those cases, the court sort of avoided the question of what the proper standard should be for a gender classification with respect to birthright citizenship. And Justice Stevens, perhaps maybe surprisingly, held in Wynn, which is the more recent of the two cases, that the classification withstood both rational basis and heightened scrutiny, which is why they could avoid the question of which standard should apply. And so now that Justice Stevens is out, and cert was granted in that case before Justice Stevens announced his retirement. So once now that he's out, it's on one hand there could have been an opportunity there because he had held that the classifications, the previous gender classification was constitutional, and so since he was sort of on the other side in that one, there could have been an opportunity. However, because Justice Kagan is recused from the case, now we've only got 8, and so it's a little bit hard to know how we would count to 5 in that case.
Did I mention one other possible effect from her recusals, which is a little different, but as you may know, there's this proposal floating around which Senator Leahy has embraced, and I think actually Justice Stevens may have suggested it, but which is that if the court is split 4-4 because of a recusal, that one of the retired justices could sit in that case. And of course, the retired justices can and do sit in the courts of appeals, and it's a way of using their expertise. And particularly as the number of recusals with Justice Kagan has grown, Senator Leahy has gotten very enamored of this idea. So it'll be interesting to see if that gets any traction and whether it's possible that we would see Justice Stevens, Justice O'Connor, or Justice Souter playing a role.
Wow. Is that a good idea?
No.
If it were 3 different justices, would it be a good idea?
Excellent. Who gets to choose which one of them? Yeah. One interesting thing is, I think Justice Kagan said at her confirmation hearings that she was all in favor of having television in the courtroom, and that's another one. I think it's not clear to me that that would go through as long as there were justices on the court who were still adamantly opposed to it. But it's an issue which will, continues to be, talked about and not nothing done about it, or maybe that's a good thing depending on your point of view. But
Okay. Do we have more questions from the press? Okay, then we can open it up to anyone else in the audience who'd like to ask a question. Yes, we've got it right over here. One sec.
I'm just interested in hearing which petitions you're most anxiously watching to decide to see what the court is going to add to its docket.
You mean other than the ones that I file?
Tell us.
From the employment and class action point of view, the biggest case to keep on the horizon is the Dukes versus Walmart case, a Ninth Circuit case. But as they very carefully pointed out, they are very much in sync with the other circuits, so it's hard to see the conflict that would be worthy of their attention. But I think that's a potentially very big case that could be down the pike. As everyone knows, that's a gender discrimination class action.
Is the issue on the certifiability of the class? Is that the issue that would be up?
That's the main
Yeah.
issue, but the plaintiff side briefs haven't been in yet, but the company's briefs are in, and they kind of throw the kitchen sink and try to bring up every issue conceivable there, and so.
Well, there's one of the interesting issues that's framed in the petition is whether in a B2 class, under Rule 23B2, which allows for injunctive relief, if the class obtains an injunction or declaratory relief, whether incidental monetary remedies can be included with the injunctive or declaratory award. And this is actually an issue that is critically important in lots of different areas, because if you succeed in stopping a particular practice as a violation of law, you might get a declaration or an injunction, and there might be monetary consequences that flow from that. But it's a different standard for certifying a class under B2 than it is under B3. And so knowing whether or not there is an incidental monetary remedy as a part of an injunctive class is a game changer for a lot of class action litigation and class action defense.
Can I address that quickly?
Sure.
The reason why I think the defendant's brief, I thought, really fell short of being worthy of the Supreme Court's attention is on that very issue. Because for 45 years, back pay has been considered equitable relief, not monetary relief, and therefore under B2. And that is what the class is seeking in that case. And the brief ignores that fact, that that's been going on for decades, and that's where I think it falls short.
The reason it ignores that fact
Okay, were you working on that too?
is because B2 says injunction, not equitable, and the back pay he's talking about is the billions and billions of dollars which are, quote, incidental to this injunction, which will affect only about 35% of the class, because about 65% of the class has already left Walmart. So whichever way you come out, I do think the court is going to recognize, for the reasons that David touched on, the importance of this issue, whichever way you come out, plus which you can't opt out of a B2. In other words, you are conscripted into the class regardless of whether or not you want to be. So again, whichever way you come out in terms of resolving this question, it clearly presents in a very stark way some very fundamental class action cases, class action issues, and I think they may take the case to resolve.
Cynthia, did you have something?
Yeah, there are, by this time, usually, the Supreme Court has taken a lot of Fourth and Fifth Amendment cases, and not this year. So I expect there are a lot percolating, and they never resist an opportunity to tinker with a Miranda or, erode away our Fourth Amendment rights. So I suspect in the coming months we're going to see the court grant cert in Fourth and Fifth Amendment cases, and maybe a couple Sixth Amendment issues that are percolating in the states.
So, Cynthia, following up on that, do you think there is an intentional move on the part of the court to just chip away until Miranda's no longer? I mean, is that your sense of what's happening, or is it just a sort of happenstance that it may look that way looking back?
I don't know that it's a conspiracy to do it. I find that the court's most recent Miranda jurisprudence, as someone who teaches criminal procedure, it becomes harder and harder to reconcile all of the cases, and where you have a right to remain silent, but if you remain silent, you're not actually asserting your right to remain silent. But it's not totally inconsistent with the court's jurisprudence in the sense of, there's a case called Hodari D, where the court says you haven't been seized if you're running away from the police and they haven't caught you. But at the same time, you have the right to be left alone and not talk to the police. And I always tell my students, what better way for me to express my desire not to talk to the police than to run away as fast as I can? And the court says, well, until they catch you, they haven't, seized you and searched you. So I think that in the area of the Fourth and Fifth Amendment, it's really confusing, and they're struggling always with, we don't want to hamstring the police on the one hand, but at the same time, we don't want to give defendants so many rights or protect individual privacy so much that the police can't do their jobs, and that constant struggle. And sometimes the rules they come out with are hard to reconcile with what we would normally regard as sort of a common sense approach. And the Miranda area is sort of very typical of that.
There was an argument back in 1989 in this Miranda line that Seth Waxman presented as his first argument in the Supreme Court. This is before he became the Solicitor General, and he was representing the defendant in the case, and he got a series of questions about what did these different cases in this Miranda line mean, and he finally stopped and he said, you know, Your Honor, I'm really sorry, but I read these cases and my brain starts turning into spaghetti. And Justice White had been kind of turning to the side, and he wheeled around and he said, well, Mr. Waxman, how do you think we feel?
That's great.
In fact, in the Supreme Court's case where they finally came out and said, you know, Miranda is constitutional, it's constitutionally required, they, for years, you know, a line of cases where they say it's not mandated by the Constitution, it's not required, and then finally, when Congress tries to punk them, if you will, by saying it's not, they can enact a statute that essentially erodes Miranda, the Supreme Court says it is constitutionally required, and I can see how you would think that we thought it wasn't constitutionally required, and then they cite all of their opinions where they say it's not required by the Constitution, it's not constitutional. But that aside, and so they are confused, I think, by what Miranda means and the viability of Miranda. So I would not be surprised if we continue to see it erode, unfortunately.
Do you have a theory about why they haven't just overruled it outright? I'm sorry, Mike.
Yeah.
Well, I mean, in much the same way as the court sort of tried to hold on in their most recent cases after Belson and search incident to arrest, it's been around a long time. It's become, you know, integral in our culture. So they don't want to completely get away from it. But at the same time, Miranda is not a big deterrent to the government in prosecuting cases. The overwhelming majority of people waive their Miranda rights. I mean, you tell them, even if you tell them and they completely understand because they speak the language and you're not being hostile, almost everyone waives their rights. And when I was a public defender, I would ask my clients, you know, did you confess? Did you make a statement? And they're like, no. I just told him what happened. So it's not.
I said I only played a little role.
I know. I did the robbery, but I didn't have the gun. I explained it all. So Miranda is. I don't think it's in danger of going away because I don't think it's a big impediment or it's a big obstacle.
Yeah. We have a question over here. Yes, in the green.
Hi, Elaine Middleman. I read somewhere, I don't remember now, that there was at least somebody's thought that the Roberts Court might go into a little more of error correction rather than just focusing on circuit splits. Does anybody have a thought about that?
Oh, if only. Well, one interesting thing is the Roberts Court has done a fair number of summary reversals, which is pretty, for those who are not that familiar with it, you know, usually, you know, the Supreme Court will only act on a case after granting cert and, you know, having full briefing. But there have always been a few exceptions to that, where the court just, you know, reads the cert petition and reads any brief in opposition and just decides, you know, this seems, you know, particularly clear and just reverses without even bothering to grant cert. Interestingly, Justice Marshall thought that was a terrible practice and always used to dissent from all the summary reversals, even when he kind of agreed with the outcome, because he just thought this is bad from the point of view of process, that the parties, you know, should be heard, and then, you know, when you write your cert petition or your, you know, opposition to cert petition, you're really focusing not even necessarily on the merits, but on whether the court should take the case. Increasingly, I just read some statistics, but I think that the Roberts Court did it, I don't know, some, you know, more than a dozen times last year or something like that, which is very unusual historically. And, you know, so they seem to be seeing a number of cases in which they think the lower court got it wrong, but, you know, just didn't think probably it was worth it to put the, or didn't want to add 16 more cases to their docket because, you know, heaven forbid they should have a 2 o'clock argument, you know. So that is interesting. And I also read something that indicated that it did not seem to be all sort of like reversing in favor of the government in a criminal case or something like that. It was much more, kind of much more varied. So that's, you know, that's one thing. I mean, all Supreme Court practitioners, you know, tend to think, oh, if only they would just take more cases. And there are all of these issues that are out there that seem to be so important. And, you know, there doesn't seem to be any movement, as far as I can tell, to increase the amount of the plenary docket. It seems the decline seems to have stabilized, you know, in sort of like the high 70s or low 80s every year. But,
you know, I think it's interesting. That's an area where a change in the justice can really make an impact. And I have no idea with Justice Kagan, but, you know, people talk about the shrinking docket that, say, in 1985 was was 150, 160 cases a year that the court was taking. And, you know, I really think, and people speculate about the reasons, and I think it's the change in personnel on the court. You know, Justice White, Justice Powell, and Chief Justice Berger were three of the easiest votes for cert for different reasons and different kinds of cases, but they were always pushing very hard for cert. So anyways, it'll be interesting.
Right, and Justice White always, used to have this practice where he would join three, meaning even if he didn't really think it would, when sort of three others did, he would make the fourth, and of course all it takes is four, and that seems to have, I think that practice has kind of fallen away also. So, you do have this, from 20 years ago was twice as many cases.
I think we have time for maybe one more question. Someone wants to? Yes.
I'm Jane Hudson from the National Disability Rights Network, and the court has taken one of our cases on the meaning of ex parte Young. Basically, whether it's a straightforward analysis of a plaintiff suing a federal official for violations of federal law, a state official for violations of federal law for injunctive relief. And in our case, it's a state agency federally created in Virginia that is suing another agency in Virginia. And I was just wondering what your thoughts were about, is the court trying to revisit ex parte Young and the extent of it, states' rights, preemption?
Does anyone want to
The only
speak
thing I will say, and I'm not an expert on that case, but when I saw the grant on the case, my reaction to it wasn't that it was a sort of fundamental rethinking of ex parte Young, but that it was, in some ways, the anomaly of the case that with this, agency, did it fit into an agency like the other ones? And, sometimes if it's a really anomalous case, the court won't take it. But because it posed a lot of kind of novel questions that haven't come up in your sort of ordinary ex parte Young context.
Yeah, there has been some thinking that the great federalism counter-revolution or revolution might have ground to a halt a little bit with the Roberts Court. That, last year the court upheld a federal law requiring institution of some federal prisoners as they were being released from prison, based on, I think, kind of a mental illness rationale, despite the fact that it didn't seem to fall within any of Congress's strict powers, and the court was divided by that. But under the Rehnquist court, I think it would have been probably a greater likelihood that statute might have been struck down. There are some countervailing suggestions in the Voting Rights Act area and so forth. So, but there has been some indication that the Chief Justice Roberts might not be quite so keen on the federalism view as Chief Justice Rehnquist was.
Well, if you look at the change in the composition of the court, the four who've been replaced most recently all had some state law background or some practice in state law or some role in the state legislature, and they all been replaced by people whose experience base is federal. You replace Chief Justice Rehnquist with Chief Justice Roberts, who is a federal executive branch official and a D.C. Circuit judge, Justice Alito for Justice O'Connor, who was a federal prosecutor, a federal circuit judge, Justice Sotomayor for Justice Souter. Justice Souter was a state law official, state attorney general, state Supreme Court justice. And now you have Justice Kagan for Justice Stevens, and Justice Stevens had a long law practice, including cases in the state courts, and understood how those dimensions worked. So you have a very different experience base that forms the background that they bring to the job. And I think that necessarily is going to affect the preemption area, it's going to affect the Commerce Clause area, and all those places where there's an interplay between state and federal law.
Very interesting. Okay, well, with that, I think we'll say thank you to our panel, and thank you all for being here.